Hi, you're listening to Principles Matter, a podcast of Celebrate Life magazine. Today we're going to discuss a distinction made between a viable and non-viable fetus. Let's begin with a hearing of the House Judiciary Committee that occurred on September 9th, 2015. Bob Goodlatte, the chairman of the committee, questioned Priscilla J. Smith, an attorney and vociferous advocate of Planned Parenthood. Listen to the exchange.
Justice Kennedy said, "The fetus, in many cases, dies just as a human adult or child would. It bleeds to death as it is torn from limb. Ms. Smith, do you believe this practice represents a humane way to die?"
Let me separate, which I think something that's getting confused here in this hearing again and again, which is procedures performed on pre-viable fetuses and procedures that are performed on viable fetuses. Both of the women here on this panel are here today because they were viable at the time the procedures were performed. What you're talking about is pre-viability procedures performed on a fetus that cannot survive outside.
Maybe not. Justice Kennedy was talking about a child that was born alive with only one arm because the other had been pulled off already in the abortion procedure. My question to you is, are you going to answer it? Is this a humane way to die?
I believe for a fetus, pre-viable fetus, yes, a D&E procedure is a very humane procedure, and
Smith actually states that D&E abortion, a procedure in which the child is dismembered alive, is a humane procedure. As you heard her say, quote, "I believe for a fetus, a pre-viable fetus, yes, a D&E procedure is a very humane procedure," unquote. It's really hard to stomach this level of cold-hearted indifference towards brutally killing a child, and even harder to stomach this awful attempt to justify such barbarism as humane based on some completely made-up legal distinction. Yeah, that's right. It's actually a completely made-up legal distinction. The distinction comes from Roe v. Wade, the Supreme Court decision that legalized abortions in 1973. The court defined viable as, quote, "potentially able to live outside the mother's womb, albeit with artificial aid," unquote. Okay, so how is viability determined? Well, there's actually no formula. It comes down to the best guess of one or more physicians, whether they think the child could survive outside of the mother's womb. Even Slate.com, which is hardly recognized for its conservative viewpoints, wrote in the late 90s, quote, "None of the methods for predicting viability are very precise," unquote. Viability is an invented legal distinction that has absolutely nothing to do with when human life begins. It's an invented legal marker that has no precise way of being determined. In this 1973 ruling, the court stated that Texas had no right to override the rights of the pregnant woman, quote, "by adopting one theory of life," unquote. But the court also acknowledged that the state had, quote, "another important and legitimate interest in protecting the potentiality of human life," unquote. The court then decided that, with respect to this important and legitimate interest, the compelling point for the state's legal ability to exercise that interest is at viability. Okay, so the Supreme Court would not accept any theory of life as a legal reason for defending the preborn, but had no problem making up its own theory with this spurious distinction between viable and non-viable? Roe v. Wade is not based on logic, and it's not based on medicine, as some would have you believe. The ruling is based on promoting an ideology at all costs. It's a twisted ideology that enables people like Priscilla J. Smith to refer to the dismemberment of preborn children as humane.